I'm going to call this public hearing of July 26th, reconvening from July 1st and 21st to order. This meeting is convened by electronic means, and council members may participate in person or by electronic means. Please leave your video on so we confirm quorum. If your video is disabled, you'll be marked absent for that portion of the meeting. Let's see. Members of the public can view the proceedings via the live stream and YouTube link, which is tweeted out at Van City Clerk. And as always, we acknowledge we're in the unceded homelands of the Musqueam, Squamish, and Tsleil-Waututh people, and thank them for their generosity to all of us who live on their lands. And thanks to staff for everything that you do. Clerks, can we have the roll call, please?
Mayor Stewart in the chair, Councillor Carr, Councillor DeGenova, Councillor Fry.
Present.
Councillor Swanson.
Here.
Councillor Hardwick. Councillor Wiebe.
Present.
Councillor Boyle.
Present.
Councillor Dominato. Councillor Bly. Councillor Kirby-Young. You have quorum, Mayor Stewart.
Thanks very much. We're moving now to the CD1 rezoning on West 18th and West 19th. On July 21st, Council received presentations from staff and the applicant, asked a round of questions, heard from speakers, and closed the receipt of speakers and public comments. Today we will hear closing comments, ask questions of staff, followed by debate and decision. And we're first going to go to the applicant to ask if the applicant has any closing comments.
Hi, it's Norman Huth with Formworks Architectural. I'm with the applicant team. I don't see our representative from West Group online, but we don't have any closing comments, but happy to answer any questions.
Okay, thanks. There are no questions at this point.
Sorry, just to clarify, I'm in chamber.
Oh, great. Thank you so much. Again, at this point, there are no questions to the applicant in the stage in the public hearing process. Just closing comments. Any closing comments?
Yes. Good morning, Mayor and Council. Thank you again for your consideration of this rezoning proposal. First, we appreciate the concerns raised by members of the public, including tenants, on Thursday night. Our goal has always been to work towards a suitable development proposal for this property through public engagement and collaboration with city staff. In pursuit of that goal, we have ensured that our application closely conforms with all existing council-adopted policy, including the tenant relocation and protection policy and Canopy Corridor Plan, a policy which was developed over 3 years, including 50+ public consultation events attended by over 5,000 people. Some of the public comment on Thursday described approval of this rezoning application as a windfall for West Group. Given the extensive public benefit offering that we've proposed, the financial viability of this project is already challenged. I'd like to reiterate that the public benefits we are proposing significantly exceed the public benefits for similar scale projects in the Canby Corridor. Where a comparable application down the street would only be expected to pay around $5.3 million in CACs based on the fixed rates, we are instead proposing a CAC offering of $5.9 million plus 25 units of moderate income housing. So those 25 units of moderate income housing are on top of the $5.9 million. This application meets and/or exceeds relevant council-adopted policy. As you've already heard, this proposal would deliver market rental, below market rental, rental replacement units, missing middle townhomes, a new park, and a childcare facility. As mentioned previously, we have been through a 7-year process for this property, including 2 years of rezoning and negotiation of the community amenity contribution value. Throughout that period, we have also incurred 7 years of carrying costs. Much of the public comment related to tenant protections, eligibility for tenant protections, and the tenant relocation process. I'll speak briefly to those items. First, with respect to tenant protections, I'd like to reiterate that the proposed tenant protections, including financial compensation and right of first refusal to return to the newly constructed rental building at their current rents, meets and exceeds the requirements of the tenant relocation and protection policy. Housing staff have also confirmed that's the case. If council feels strongly that the proposed tenant protections are insufficient and council are inclined to amend this application to require rent top-ups, we are prepared to be flexible if council are willing to deduct the additional cost from our public benefits offering. I'll just repeat that. We are prepared to be flexible if council are willing to deduct the additional cost from our public benefits offering. This project cannot otherwise support these additional costs. That was confirmed in the CAC process, in which the land lift was extracted through a pro forma review process with staff. If a rent top-up is required, tenants would not receive a one-time financial compensation at the time of displacement as currently contemplated under the TRPP, because the purpose of that one-time payment is to bridge the gap between current rents and market. However, to be clear, the method of calculating rent top-ups remains undefined, as it does not exist under any approved policy. As you know, the Broadway Plan amendment directed staff to report back on this item. So while we understand conceptually what it might mean, it's impossible to forecast the value of the rent top-up at this time. Councillor Swanson spoke about the idea of directing public art funding toward increased tenant protections. While we don't know practically how that might be applied by staff, in principle, we are supportive of prioritizing tenant protections over public art for this application. Please understand that we absolutely acknowledge the issues presented by many people during the public comment. The challenge we face is that we're working within an existing council-adopted policy framework, and the city has prioritized various other needs and wants, such as childcare and moderate income housing. If rent bridging had been a priority, we would have included it a long time ago. If council approves this application as currently proposed, we will deliver the public benefits described in the referral report and provide tenant protections, including the right to return to the new building at current rents in accordance with the tenant relocation and protection policy and Canby corridor plan. As already noted, we will work with current tenants on a case-by-case basis to provide support, additional support, for those who demonstrate genuine vulnerability and are facing housing insecurity. Secondly, I'd like to comment on the tenant relocation process. Some of the comments suggested that West Group has failed to adequately communicate with tenants. Again, staff have confirmed that we have adhered to the process outlined in the tenant relocation and protection policy. More specifically, I'd like to briefly summarize some of our communications with tenants dating back to 2015. In July 2015, West Group sent letters to all tenants alerting them of West Group's acquisition of the property and intent to redevelop. Between July and August 2015, individual in-person meetings were conducted by West Group. November 2015, a follow-up letter to tenants was provided by West Group notifying them of the Canby corridor planning process. September 2017, another update letter from West Group. July 2020, a letter from West Group alerting tenants of our forthcoming rezoning application. June 2021, an introduction letter from Somerville Community Relations and phone calls to all tenants by Somerville. July 28th, 2021, an all-tenant virtual meeting was convened and attended by West Group, City of Vancouver housing staff, Somerville, and tenants. A question and answer session was conducted. Tenants were provided contact information for the project team and invited to reach out with any questions. More recently, in June 2022, Somerville and West Group provided another update letter attaching a frequently asked questions document, including updates to the approved TRPP, rental protection, and provisions as described in the council report. And more recently, more outreach by phone. Through our communication with tenants, we've sought to strike a balance between conveying information about the tenant relocation and protection policy, the rezoning application, and the relocation process, while not communicating too frequently in a manner that could cause stress or create a sense of pressure to relocate. Please understand that we've been seeking to strike a balance of communication frequency. As our tenant relocation specialist has said, tenant engagement is not a one-size-fits-all process. Our team is working within the TRPP policy framework and using judgment to guide our communication strategy. With respect to the eligibility of tenants who moved in after the rezoning application was submitted and are consequently ineligible for tenant protections under the TRPP, we chose to re-rent the available units during the interim period and specifically disclosed those tenants that the property was planned to be redeveloped. There was some public comment about the substance of an addendum which formed part of the lease agreement for tenants who initiated tenancies following the rezoning application. As previously mentioned in my opening comments, that addendum includes an acknowledgement saying that tenants will not initiate dispute resolution proceedings or dispute a notice to end tenancy. It also includes confidentiality provisions. As a point of clarification, I'd like to read some relevant clauses from that. First, the tenant hereby acknowledges and agrees and consents to the following. The landlord has acquired the lands upon which the rental unit is located for the sole purpose of redeveloping such lands, and the landlord intends to demolish the rental unit and redevelop such lands in the future, which redevelopment will require the rental unit to be vacant. The rent payable by the tenant hereunder is substantially below market for rental units of similar size, location, and quality, and such rent is discounted because the tenancy hereunder is intended to be for a short-term tenancy, and the tenant will benefit significantly from the foregoing. The tenant will not be entitled to and will not claim any tenant relocation fee, moving allowance, or any other compensation, payment, or amount whatsoever in connection with the tenancy ending, except to the extent expressly required under the Residential Tenancy Act. This addendum affirms the terms of the tenant relocation policy. We ensure that those tenants understood the nature of their tenancy in a property that was undergoing redevelopment, and that they also understood that they were being offered below market rent as a result of our redevelopment plans. We still feel that renting these units was the right thing to do rather than simply leaving them vacant. In doing so, we were able to keep additional rental housing units on the market. We believe extending tenant protections to these ineligible tenants will discourage other applicants in the future from renting any vacant units during the rezoning process. If this project is approved today, it would mean a 10-year duration from West Group's acquisition of the property to the first key being turned into a completed unit. We ask you to approve this application, and if an amendment is sought to alter the tenant protections, we ask that Council offset those additional costs from other public benefits. In short, we urge you to approve this application in a manner that will preserve its financial viability and thereby allow us to proceed with the creation of new housing options and public benefits. Thank you.
Thanks so much for your closing comments. I am going to move on to staff to ask if they have closing comments. Then we'll move on to questions from council to staff. Again, at this point, we can ask questions to the applicant. Go ahead, staff, with any closing comments.
No comments. Thank you.
Thanks. Okay, we're going to move to questions from council. Councillor Carr, up to 5 minutes. Questions to council to staff.
Yes, thanks very much, Mayor. Thank you for those final presentation. So my questions start off with eligible versus ineligible tenants. How many eligible versus ineligible? And if you could just explain so it's clear on the public record, what makes a tenant ineligible?
Thanks, Councillor Carr, for the question. Annie Mobilis with Housing. So currently, according to the city's tenant relocation protection policy, there are 24 eligible tenants out of 34 total. And eligibility is based on length of tenancy. So they need to have been living there longer than 1 year since date of application.
Right. Thank you. That's very clear. Second question. If we extend tenant rights to, like the Broadway plan, to the eligible, even the eligible tenants. The applicant just said that he would want to see this deducted from their public benefit offerings. So let's get clear about what those are. That's below market rental units, childcare facility, a park, and public art. Is that the list?
That's correct. Yeah.
Right. And we can even include public art in that list.
Yeah, that's correct. I don't know if Cynthia would like to.
Councillor Carr, Cynthia Lau, Senior Rezoning Planner. Public art is a public benefit, but it is calculated as part of the overall package of benefits. And to note that changes would be challenging at this time and may result in a need to further analyze the CAC at this time.
Would that delay the project, the further analysis, or does it come as a condition of approval, which you would then work out afterwards?
Yes, if it is significant, we'd need to take that back.
And how do we know as council whether it's significant or not? I mean, if the language was something like as a condition of approval, have tenant rights extended to eligible tenants like the Broadway plan conditions
That's
with
likely quite
amounts deducted.
significant. That would be significant.
That would be significant. So that would mean what would happen to the project?
It depends on the decision that council would be making. If it's referred back to staff, then we would have to renegotiate with the applicant.
No, I didn't ask. I didn't use the words referral to staff. I just said as a condition of approval, which I know then you work on.
I think it's a kind of a judgment call, Counselor. It really is. If the application changes in such a way that the public notification wouldn't instruct the public that this is the application before the council. So if the childcare went away, if the green space went away, if there was a recalculation of the CAC, those would all be, in our interpretation, significant enough to go back to staff and trigger another public hearing.
What about the public art?
The public art would indeed.
And it would include that. So anything that changes that. Okay.
Yes, and we actually even ran that question by law specifically about the public art, and that was their response to us.
So any changes to the public benefit offering would change the application that went to the public.
Right. We would need to re-notify the public, because a member of the public might think, well, I wouldn't have spoken out normally, but now that there's not a public art, maybe I'll speak out now. Maybe I support that, maybe I don't. But it would influence their decision to participate in the public hearing.
Okay, you've made it very clear. Appreciate that. Thank you.
Councillor Boyle.
Thanks, Mayor. I had a similar question, so maybe let me just continue on it, because I understand a significant change and the green space or the childcare being part of that, a major shift in density. But I guess I'm trying to understand on the public art, because it is not a subject we heard from any speakers. It seems like a very small segment of the overall CAC package. Is it at staff's judgment that would trigger it going back? Is there something legislative about it if council were to say staff could renegotiate the public art contribution? What requires that to go back, and where's the discretion, given we've heard that's a willingness on the part of the applicant?
Thank you for the question, and I certainly welcome my colleagues from law to jump in to help me if they'd like. But we could assume, maybe rightly, maybe wrongly, that we didn't hear about public art because it was understood to be part of the package. That may be correct. It may not be correct. It may be that no members of the public care about the public art contribution, but we can't assume that, because that is a substantial change to the application. Hope that answers your question.
Do we have like and I can understand if you wouldn't have this right away, but a sort of percent figure of what the public art, what portion of the total CAC package the public art is?
Can you hold on just a second? Yes, the public art isn't really part of the CAC negotiation. It's part of the amenity package.
Okay. Do we have a calculation of what percentage of the amenity package it is?
Yeah, they're looking that up right now. Yeah. Counselor, if you'll just give us just a moment.
Fair to not have that off the top of your head. But I have another question, which is there anything, I mean, we have all been listening. There's a strong interest from residents in seeing rent top-ups. There's a willingness on the part of the developer or the applicant to do that. Is there any option that exists for council to say that's a priority for us, and negotiate this, figure out that? Like, are there possibilities of what we can give a little at the direction of council at this last stage to make that happen?
That's a hard question, and we spent quite a bit of time discussing that with law and members of the staff yesterday, and we really do believe that if council would like us to renegotiate the tenant protection package, that's a decision that should be sent back to staff and the applicant to look for ways to offset that additional financial implication. I know that's not the answer that the council's looking to
I know, I guess
hear.
I'm wondering, do you have a sense of how much it costs for the project to be sent back and renegotiated and delayed a year? It just seems to me like that is a worse outcome.
I understand your point, and I don't know that there's a particular magic number that that's a threshold that we change. It really is the fact that we're just changing the package. We're changing the financial package. And Cynthia's telling me that the CAC, the applicant has estimated that that's the public art is approximately $400,000, and it would be actually a small percentage of the public benefits. Is that 4% of the public benefits.
Okay, thank you for doing that that on the spot math. I will leave my questions there.
Councillor Swanson? Councillor Swanson?
Do we know how many Balfour units there are in the city? I know there's lots in Kits.
Councillor Swanson, Cynthia Lau, Senior Rezoning Planner. While it's called the Balfour Block, this block was purchased by the West Group Properties about 7 years ago, I understand, so I don't believe that it's connected to Balfour Properties anymore.
Okay, thanks. When we talk about the CAC package, does that include the daycare or is there some cash involved?
Hi, Councillor. The CAC includes the childcare and the park space, but the overall public benefits also includes the DCLs and the public art.
Okay, and DCLs can go to childcare, can't they?
Yes, that's correct.
We shifted some DCLs over to childcare. Maybe there'd be some extra dough there for tenant protection.
It would be something that would be explored through the capital plan process to move around DCLs.
Okay, thanks. Will there be enough 2 and 3 bedrooms for returning low income 2 and 3 bedrooms for returning tenants?
Thanks for the question, Councillor Swanson. Annie Mobilis with Housing. For eligible tenants in our analysis, we believe that there are enough 2 and 3 bedroom units to match our measure, which is the National Occupancy Standards. If all tenants were deemed to be eligible, that would be more challenging. But we believe that the 2s and 3s for those eligible tenants with the current proposal could be accommodated. There are some people, families living in 2 bedroom units that could use a 3 bedroom and vice versa. But if it was for all 35, that would be more challenging.
Will we have vacancy control for the market units?
For the portion that's below market, we would, yes.
What does staff think of the idea of developers being able to create new developments where they actually don't replace the affordability that they're basically demolishing? For example, in this case, there's 34 units that are relatively affordable, and the theory is to replace them with 25 that are relatively affordable, but we actually lose 9 units of affordability. Is that Is that a good policy to have?
Thanks for the question, Councillor Swanson. You know, staff provide their analysis and review on the policies that we have to refer them, refer an application to. And so in this instance, the project is meeting the housing policies in the Canby Corridor Plan unique sites. We do try to maximize the percentage of units that are affordable, but it is part of the overall financial analysis. And with other, public benefits that also are negotiated, it can be hard to do a one-for-one replacement, but it does meet the unique sites housing affordability policy in this instance.
Okay, I know you have to go on the existing policy. I just don't agree with the existing policy. Okay, thank you.
Thanks. I've put myself on the queue for questions, and mine's more procedural, so I'm hoping planning and law can help me. So every public hearing, which has been many of, I say this is a quasi-judicial process. And I'm just going to kind of ask for confirmation as I go through from Jeff Greenberg or perhaps Therese O'Donnell. And so essentially what a public hearing is, in my understanding, is that a builder buys a plot of land and wants to change its use. And then there is a process by which they enter into where they work with staff to apply existing policies that have been and bylaws that have been passed by council to that plot of land to see what's possible. I'll just stop there. Have I broadly got that right to this stage?
Yes, Your Honor, that's true.
Okay, great. And so then what happens after staff and the applicant kind of think they've got it right? It's presented to the council, like entered in an official process, right? We pass we agree as a council and vote to send it to public hearing, but then it's presented to the public. The actual the broad terms of the agreement are presented to the public for comment, and then that kind of locks in what we can discuss at the public hearing. Is that broadly right?
That is correct. And in fact, we notify the public before the application is scheduled for referral or public hearing at council. So the public is aware and has time to understand and absorb the application prior to it being presented at the city council.
Right. And so let's say in the middle of this process up to this point, council makes some massive change to policy where we either require something or take something away, say we reduce the DCL rate. That wouldn't apply to this project because once it's entered in, it's kind of locked in terms of existing policies. Is that broadly right as well?
Yes,
Mayor,
go ahead,
Mayor,
Jeff.
the DCL rate is set by a bylaw, so that would require a bylaw change to change that. Other things that you're referring to, which are policy, you can decide to follow the particular policy or change the particular policy. That's within council's discretion. So you can simply say, I'm not going to apply this particular policy to this particular project, and these are the valid reasons why I'm saying that. Or you can say, I don't like that particular policy at all, and I'd like to change that policy. Best not to change policy on the fly, but again, that's within council's discretion to do so.
There is an element of good faith bargaining here, though, as well, right? That you're kind of establishing the terms at the beginning with the applicant as to what the rules of the game are, essentially. Is that what you think?
Yes, I would completely agree with you, Mayor, that I not necessarily would call it bargaining, but the applicant is making a proposal based upon negotiations and discussions with staff as to what is a appropriate proposal that the general manager of planning development and would recommend and refer to council. And that is then going to council for consideration. Council has the discretion to approve or not approve or refer it back or to make the changes that it wishes. But the applicant is going on the basis that this is acceptable, at least at a staff level, for the application to move forward.
Right, and essentially through these CAC negotiations and the set rate of the DCLs, there is kind of a pie of money that's available for public use. Is that kind of, a certain size pie? And then through our policies and deliberations, we distribute that pie according to council priorities. Is that also more or less correct?
Yes, I would say that's also more or less correct. The basis of determining this pie is a pro forma that would be submitted and analyzed by staff, coupled with requirements for the delivery of certain public benefits, such as the public art that you've spoken about a couple times. The public art is established by policy, the rate is established by policy, and it is one of, I would say, the more higher level policies where it's not really a negotiation as to the amount of public art. It's set by a rate that council has approved.
Right. Okay. I think I've got that. All right. And I'm at my 5 minutes. So thanks for the clarification. Councillor Fry, up to 5.
Yeah, thank you. And that was very helpful from Jeff Greenberg there. So seeing some of the amendments that are sort of floating around on the council queue here, and having heard from the applicants that this might impact the viability of this project, I'm curious from staff, and many of my questions have already been answered, but what would if an amendment was to say, spike this whole project as it's been proposed and it was no longer viable for the applicants, what is the possibility to do outright on this location, and what would it mean for things like tenant relocation and stuff? If you could just walk through the kind of outright zoning use for this parcel.
Susan Chang, Development Planning. The current zoning on the site is RT2, which would allow for 2 stories, and I believe it's 0.7 FSR.
So no obligation to replace it with rental housing or anything like that. It could just be.
Yes, no, there is no tenure applied.
Sorry, Annie Mobilis with Housing. Just wanted to add to that, the rental housing stock official development plan wouldn't apply under RT2 in this case.
Yeah, and I'm asking this really just as a very hypothetical, just because I'm listening to what's being said and I'm seeing what's being proposed as amendments. I'm trying to wrap my head around what that might mean if this project doesn't go forward. Okay, I might come back on. I'm gonna pause for now. Thanks.
Okay, thank you. Councillor Dejanova.
Thanks so much. I have a question, a point of information, or I suppose we are in questions. Mayor, to staff. A number of speakers have talked about a breach of confidentiality in their privacy and their information, and I'm wondering if staff could comment on that.
Hi, Councillor Dejanova, Cynthia Lau, Senior Rezoning Planners. The breach of confidentiality occurred through an IT breach on behalf of staff, as there were confidential information that was included as part of the package from the applicant. And while our website was in draft stage, it ended up being able to be searched online. Staff undertook a significant investigation on that, and we've changed our processes since then to ensure that such a breach would never occur, or has very little chance of occurring again in the future.
Okay, and all of that's been remediated, obviously. I just want to make sure that for the public record.
Yes, that's correct. We've changed our processes.
That information is no longer accessible online.
No, it was immediately removed.
Okay, thank you very much. I appreciate that. Some of my other questions have been asked, and I do see some amendments floating around, so I'll reserve my comments at this time and wait and see what happens. Thanks.
Okay, thanks. Councillor Weed, questions to staff.
Yeah, first question is the third food asset. What are we expecting as a third food asset as part of sustainable building plan here?
Staff from ACCS, Andrea Haber, will answer this question.
Hi, Andrea Haber from Social Policy. The third food asset will likely be negotiated or determined during the development permit.
What are the options? What could the public see? What would we expect?
Staff?
I think I'll have to get back to you on that one.
Okay, my next one is recognizing that we have some tenants on site and there's an ABC plan in the phase. I'm wondering, was there an opportunity to phase in this plan so that tenants would have less time between having to move away from their home to relocate back into the facility? So was a phased approach considered, and is that still a possibility?
Annie Mobilis with Housing. It was part of our discussion with the applicant. I think one of the challenges is just the sequencing and access to the site. And so currently the rental housing building is, I think, second to last in the build out. But we did discuss trying to land that building earlier to minimize the disruption. Hope that answers your question. Cynthia?
I have the answer for the food systems, and currently the applicant's pursuing edible landscaping, urban agriculture plots, and on-site organics management, and they're also exploring a potential community kitchen.
Okay, that's great to hear. So recognizing the park space is last, was that seen as maybe a swing spot, or was there portions of C that were able to be kept longer, or is that going to significantly increase development costs, and that's why it wasn't pursued by the applicant?
Councillor Weber, are you speaking to the
still
phasing?
into the phasing. Yeah, I'm still into the phasing idea, recognizing I think the less time between relocating for a young family would be kind of something we heard from a lot of the tenants. So I'm just wondering, was there any opportunity with the park and some of the changes in the final thing to have one or two buildings kept so that we could have few of the families that were most in need to be able to stay on site as long as possible?
We'd be working with the applicant through the development permit phases and further development phases on that. And we'd put efforts into ensuring that we could deliver the project while ensuring least disruption possible.
Okay, thank you very much.
Thank you. Councillor Dominato, questions up to 5 minutes to staff.
Thanks, Mayor, and thanks, staff. Yeah, a couple of quick questions. One, can you just reflect back to me the assessed value of the rent bridge funding that's proposed in an amendment that's forthcoming?
Annie Mobilis with Housing. We've done some back of the napkin analysis just based on average market rents and the current rents that the tenants are paying. And we estimate it could be for all tenants, even those that are not eligible under the TRPP, over $2 million.
Okay.
For the rent top up, which currently the TRP package includes right of first refusal at the same rents and a unit size that meets your national occupancy standards, as well as compensation. So tenants, while they're waiting to come into their new home, as part of the TRP package, are eligible for compensation lump sum until they return.
Right, but not the rent top up as proposed.
No, that's not currently part of the TRP for this site or citywide.
Okay, thank you. I appreciate that. And then I guess in tangentially, what I heard and I want to reflect it back is that GM of Planning, Teresa O'Donnell, said that that to move in that direction would necessitate renegotiating with the applicant, and that would be best suited to be done through a referral. Is that correct?
Yes, that's correct.
And do we have a sense of the willingness of the applicant to support a rent top up in that manner and to engage in those further negotiations? Or because what I did hear was that it likely would sink the project, but I just want to be clear on that point.
Councillors, we're in a public hearing process. We are not able to discuss that with the applicant at this time.
Okay. And then did we include the top up in the TRPP enhancements for the Broadway plan?
Yes, the rent top up is part of Broadway plan TRP, but it's not currently part of the citywide TRP.
Okay. And can you remind me the Broadway plan is not enacted yet. Is that correct?
Yes, that's correct.
What's the date of enactment?
Clarify, it's not, the Broadway plan isn't a bylaw, it's a policy, and policy comes into effect September 1st for us to receive applications.
September. Okay. And so you're not able to talk about the discussions with the applicant at this time. So it would have to be done as a referral.
Correct.
Okay. Thank you. That's it. Questions?
Thank you, Councillor Dominato. Councillor Swanson, you have about 50 seconds.
Yeah, if the rent top up is $2 million, if everybody got a rent top up, then they wouldn't get the payout. So do we know what the value of the payout is for moving?
That's correct. There wouldn't be the compensation necessarily. I mean, Broadway plan, it's either or. We've done some looking at current rents and length of tenancy, and the maximum amount for those that have lived there longer than 20 years would be just under $27,000.
But do we know what the total amount of payout is? I'm just thinking that.
I see. Yes. Again, just doing some quick analysis, we believe it to be approximately $600,000.
600,000?
Yes.
Okay, thank you.
Okay, that's it for questions. So can I have somebody move the recommendations, please?
So moved.
Second.
Okay, moved by Councillor Weeb, seconded by Councillor Deja Nova. And I'm just going to pull us over to the queue here. We're on the, it's going to clear that queue. We are on the debate queue now, so folks want to put their names on if they want to debate. Okay, Councillor Boyle.
Thanks, Mayor. I have been wrestling with all parts of this application, as I know many of us have been for the last couple weeks, and certainly struggling with the balance of having heard from the tenants and understanding the realities of what it will be like to try to find interim housing elsewhere, particularly trying to keep kids in a local school or other challenges like that, as well as the challenge that this is an application that does meet our current TRPP, even if we are moving in the direction of strengthening that TRPP elsewhere. So I just want to name that very real tension between the lived experiences of the tenants there and the policy that we currently have in place. I have circulated an amendment. Maybe I'll pause to see if it's seconded and move to an amendment queue.
Okay, just waiting.
Second.
Okay, thank you. We're on amendment queue. Councillor Boyle, did you want to?
Yes, and again, I just I want to acknowledge how difficult, and you can tell from the questions many of us have asked, how difficult this tension is to be meeting the needs of the tenants and trying to keep a project viable. My sense, I certainly heard that there's a gap between the cost of the payouts as currently proposed and the cost, what could be the cost of bridge funding if everyone took it on. And my sense is that sending the project back, a referral back, would add more time and more cost than that difference would be. And so in the balance of things, I think that this is a better approach to be adding a top up here. So just to be clear, this amendment asks to or directs to enhance the tenant protection plan to include the existing right of first refusal at the same rent, the right to an appropriately sized unit by CMHC national occupancy standards, as well as the additional right to bridge funding in the interim, as well as that council direct staff to work with the applicant to increase the number of 3-bedroom units, and further to explore phasing of construction to minimize disruption. Again, I know we're in a very tough spot here where the options aren't great, and the risk of sending a project back versus leaving a number of tenants in a very difficult spot is a complicated issue for all of us that we weigh heavily, and this is what I am proposing.
Okay, thanks so much. We've got Councillor Dejanova next on the queue.
Thanks very much. Mayor, I'm wondering if I can ask a point of information for you to staff.
Sure can.
And I realize we are in a quasi-judicial, body. That's how we sit when we're in public hearing, and we can't go back and forth with the applicant. But I'm just wondering if staff can share if any of their discussions with the applicant before bringing this forward, also sort of considered some of the approaches that are outlined in this amendment, and if staff could comment on if the applicant said that this would make the project unviable for them.
Staff?
Councillor, to the first part of your question, no, we hadn't discussed these changes with the applicant prior. And as to your question about the project viability, staff's not in a position to answer that. The applicant could either make these changes and absorb those costs, or they could elect not to enact, or they can enact the rezoning and come back for a text amendment at a future date.
Okay, thanks. And just to follow up to that, if this didn't work out for the applicant, as you said, they could bring back another application, which would mean going through the process again. So would it be more, would it expedite this to refer it back to staff, or to have these specific conditions outlined? I'm just wondering if staff can give us an opinion on that from your expertise.
I think this amendment would be the most expeditious route.
Okay, that's good to know. And for that reason, I will be supporting it. Appreciate this being brought forward. I too was considering amendments. It's really difficult. And what I'll say is I did, I'll make some of my comments here and maybe reserve some for the end. But what I will say is, I certainly heard that each and every one of the tenants who spoke with us were speaking, from the heart, and not just on their behalf, but on behalf of their families. Some living, in this building, and putting down roots and creating their lives, and building not only families but friendships and a community. So for that reason, the fact that this would offer some extra tenant protections and some certainty for them that they could return. I think that this is probably the best way forward, considering what we have, and we can't ask the applicant any further questions. And I think that it is important that, we consider time is of the essence, and that the longer we wait and we force the applicant to wait, the more expensive the market rental housing becomes. So for that reason, I will support this amendment.
Thank you. Councillor Kerr.
Thank you. If I could ask questions points of information through you to staff, please, Mayor?
Sure can.
Okay, the first clause of this amendment, the council enhance the tenant protection plan to include the existing right of first refusal at the same rent. Is that not part of this package already?
Thanks, Councillor Carr. Annie Mobilis with Housing. The only thing that's different is the rent bridging.
Yes,
So
okay,
the,
so
the
that
tier,
first clause is already in there. It's redundant, in other words, because it's already in the package.
except that rent bridging, that's right.
Yes,
Yeah,
okay.
compensation, right of first refusal at the same
I'm
rents.
going phrase by phrase, so that's
Yes.
my first question. Just want to, the right to an appropriately sized unit by CMHC National Occupancy Standards. What is the implication of that in terms of the right to versus what I heard staff say that, in answer to some earlier questions, that actually there are likely enough units to be able to give to the eligible tenants on return of that size. I mean, can we do that? I've never seen this right to an appropriately sized unit. It's a good idea, but I've never seen that before.
Yeah, it's an occupancy standard. BC Housing actually follows it as well. And so in our analysis of the eligible tenants currently, and we're still early in the TRP process actually, we did determine that even though there's an overall reduction in 3-bedroom units, that the current household mix should be able to fit into what's being proposed, although, can't 100% say that because that changes as we get into the development permit drawings. Sometimes the unit mixes change. But for eligible tenants, we feel that we could accommodate that national occupancy standard of family unit mix.
Okay, so that's likely to happen as the process unfolds. All right. Third clause, the right to bridge funding interim needed to make the tenant protection stronger. Isn't that we just spent an hour talking about? And didn't the applicant say that this would not be possible, or we'd have to refer the whole thing back to renegotiate that?
We can't speak to what the applicant thinks. We did hear that in their closing comments. We haven't had a chance to speak with the applicant about bridge funding. It's unclear what the impact would be.
Yeah, but you did say that if the bridge funding is going to come from somewhere, especially if it's going to come from, it can only come from the benefits package or the applicant.
That's correct.
Right. Yeah. So we heard clearly in the answer to questions that anything to do with the money to enable this to happen, if it came from current public benefits, that would have to go back to the drawing board for the public to relook at.
That's correct.
Okay. And we heard from the applicant. Again, this was just in this morning here. The statement made by the applicant in closing comments was the project would not be viable from their point of view if we added in tenant protections.
That's correct. Yeah.
Okay. I would love to see these move forward. We have included these in the Broadway plan. We have included these in the Vancouver plan now, but those are still getting all worked out. This is the way to go for tenant protections, but in all good faith, I cannot refuse this project now or make a decision which I know is going to end up to the project not going forward. So I'm not going to be able to support this. I would like to, but that's what I believe my choice is. Supporting this and then the applicant saying can't do it because they said that, or letting this project go forward. I want to see this project go forward.
Thank you. Councillor Swanson.
Yeah, 3 questions to staff. So this would just apply to this development, right?
Yes, that's correct.
And to all the tenants, not just the quote eligible tenants?
This, my understanding is this is for eligible tenants, this amendment.
Okay. And would this mean that the project has to meet these requirements or else come back to us? Or
Yes, it would. If it was approved, it would need to meet this test, and that we would operationalize that through and implement that through the tenant relocation plan as it moves into development permit.
I think we're getting close here to making it financially feasible from what I've heard. If we take out the public art, if there's no payout because people are getting bridge funding, that's $1 million right there. And if we can get the rental building up first, then we wouldn't need the bridge funding. So, or at least for most of the tenants. So I think we're getting close so that the staff and the developer can negotiate. I would like to change it so that it applies to all tenants. But I'll see if I can do that here. That's it for me.
Thank you. Councillor Fry?
Yeah, so I'm wondering actually, Mayor, I guess it's too late to ask questions of the applicant, I'm assuming.
That's
Yeah.
only the first base, yeah.
Can I ask a question through you of staff then?
Yep, sure can. Information, yep.
Yeah, so so I just want to be 100% clear. So basically this amendment will mean that the CAC presumably, or the public benefits, would have to be renegotiated to pay for this, and then this has to come back to public hearing. Is that the gist?
Councillor, the way I read this is it's not a reopening of the CAC. This imposes an additional cost on the project, and it would not need to come back. We would take this away as instruction to staff. We would have conversations with the applicant. The project could either absorb the costs or it wouldn't. If the project can't absorb the costs, then the applicant can withdraw this application and submit a new rezoning application, or he could develop under the existing zoning through a DP, or he could enact this zoning and then come back with a text amendment to redefine the project costs.
Now, assuming if they're, and again, we can't ask the applicant this directly, but if they don't see this as viable within their sort of pro forma, could they try and renegotiate the CAC or public benefit component, and then it would have to come back to public hearing? I'm just trying to see what the roadmap forward on this realistically, if this amendment.
Yes, if they thought the project was no longer financially viable, they would that would trigger a new application. We'd run it back through the process.
So, I mean, realistically, do you think, and I realize this is a big kind of assumption, but what does this mean for this project moving forward? Does this delay it, and then we look at inflationary costs that potentially change the pro forma as we delay this by X amount of months or years?
I'm not in a position to speculate on the project viability, sir.
Yeah, that's fair. That's fair. I'm struggling with this for those reasons as well, because I don't know how pro formas and business economics of housing development work. So I'm worried that this kicks us down the road and makes it unviable, and then we end up with no rental housing out of this at all. Okay, I see others on the queue, so I'm gonna just think.
Councillor Dejanova, I have just under 2 minutes.
Just a quick question to staff, and then I'm not sure, a point of information, Mayor. Let me change my mind on this. I understood from the GM of PDS that this would be the most expeditious way. Am I understanding that would be more expeditious than a referral process back to staff, but only if this is viable? If this isn't viable, it's square one, we're starting out again. Is that what I'm hearing?
That's what you're hearing. And the reason I think this is the fastest way back is it gives staff a very clear direction about what the council's looking for, as opposed to if we refer it back, it might open it up for other discussions. But this is crystal clear, the changes that the council's looking for.
Thank you very much. With the last few seconds I have, I'll say that I have worked with pro formas, and I do understand that the applicant's also been very crystal clear in saying that, that there isn't more funding right now that they can pull from their pro forma for this. So I'm concerned that without being able to ask them, that this will be inviable. So although before I was willing to support it, I don't actually see this as the most expeditious way forward, because I'm concerned this could cause the entire application to fail and we'd be back to square one. So for that reason, I'm not going to be able to support this amendment. Thank you.
Thanks. Councillor Boyle, 3 minutes.
Thanks. I have another question for you to staff, if you'll allow it. I just heard the GM of Planning mention a text amendment, that there was a possibility that the applicant could enact this zoning and bring back a text amendment that would reconsider some of the financial pieces. Can you just say more about that option?
So that's always an option that's open to applicants. They can enact, they can go through, they can prepare their DP and go through all the necessary steps to enact this zoning, enact the zoning, pay the fees, create the tenant relocation plan. And then, and once it's enacted, they can come back with a change. They can come back with a text amendment to actually change it.
And could that text amendment come back and say, do something like waive the public art contribution, or request a waiving of the public art contribution given the fulfillment of additional tenant protections?
Let me ask Yardley to help me with that.
Thank you for the question, Councillor. It's Yardley McNeil. It would, if it came back to staff to apply a tenant relocation package that was more expensive than what's currently proposed for the application, then we'd be negotiating with the applicant on what that means with respect to their project. Incentives that could offset those costs could come in many different forms, and we wouldn't want to prejudge what that could ultimately be and what staff recommendation would be at that point.
Okay, but those changes could come back as a text amendment instead of an entirely new application?
It would be a new application. Sorry, just to be clear, a text amendment is an amendment to a CD1 bylaw. It means it's a new rezoning application with potentially a new form of development and a new CIC package.
Okay, sorry, that's what was not clear in my head, and I appreciate that clarification. Thank you. That's all for me.
Thank you. Councillor Swanson, you have 3.5 minutes or so.
I sent an amendment to the amendment.
Okie doke.
This is just to make it apply to all the tenants instead of the 24 remaining.
Okay, we need a seconder for that. We have a seconder for that one. Going once, going twice. A seconder for this amendment.
I'll second it. I think it's a good conversation to have.
Okay, Councillor Weeb seconded.
So I think it's really important that we establish the principle that we don't reduce the amount of affordability that we already have. And that's the purpose of this. I think it's especially important because we've got the Broadway plan and the Vancouver plan, which want to increase density all over. So developers are going to be buying up land and wanting to put in new developments. And if we're chasing out the people that are, working at Starbucks, working at, one woman said she was a social worker at the hospital, if we're chasing them out, we're not going to be meeting our climate goals. I think from what the staff and the applicant have said, we're very close to being able to do this. The staff said the payout was $600K based on all the tenants. We've got $400K worth of art, so that's $1 million. We could have. They say the whole cost of the top up is $2 million. If the building gets built quicker, then then there won't have to be any top up for a lot of the tenants. So we're getting very close. And I think it's worthwhile to go ask our staff to go back and renegotiate this as this motion calls for. And see if we can, just up the pressure a little bit to protect the tenants and to get the affordability that we need.
Okay, Councillor Weeb.
Yeah, so I won't be supporting the adding all current tenants because I think that this creates a dangerous precedent, and we're seeing this with buildings come to council that have 2 of 32 units occupied because the developers aren't putting in temporary tenants because they recognize that it is easier to just have a vacant building. And there's a significant amount of stock. We're seeing it starting to happen in the Broadway plan, where I'm hearing more and more buildings are being emptied out. And I think that this would create a really tough precedent when we're trying to ensure that we can keep renters in the area, kids near their schools, and try to find ways to make this tenant relocation as we move people around the city. I think this is a really dangerous precedent, and it puts us further away from trying to make this project feasible. So I will not be supportive of this.
Councillor Boyle?
Thanks. I also reluctantly won't support this. I share the concern, Councillor Weep articulated, that the result of this would be a lot of vacant rental units in buildings that might be seeking redevelopment down the road. I think that's a worse outcome. I am sympathetic to the challenges that it puts those tenants in, but I'm really trying to thread a needle here. I don't know if that's the right metaphor, a balance of being able to see this project continue to move forward. And I think this tips those scales far too much, and with that risk that it will result in a lot of empty apartments not being rented out for years. So unfortunately won't support it.
Councillor DeGenova.
I just to pick up where Councillor Boyle finished off, I'm more concerned that this entire project won't be viable if we move forward with this. I understand where the sentiment's coming from, and I think that we all are trying. We are, you know, regardless of what metaphor we use, we're trying to do what we can to make sure that we meet our housing goals, council, and our targets to provide more affordable housing. It's been a bumpy road over these past 4 years with changes to TCL waivers, and changes to, you know, the TRPP. But that being said, I also think that we have to consider the ramifications of not having new housing come online and some of these amenities as well, including childcare spaces. My concern is with this, the entire project won't be viable. So as my colleagues have stated, their reasons for not supporting this, I think we might as well just vote no to the whole project if we're going to vote for this amendment. And as someone who has worked, you know, with pro formas and understands that you know there's just no more money to take out of a line item, and there's no way to make that work. And that's what we've heard from the applicant. We heard it in their closing comments that, you know, they have come to the table with the most that they can give. We also heard through staff recommendations that this is what they had negotiated and had come forward with. So it's difficult. We're tying our own hands by not being able to ask the applicant because of the process we're in, but understanding that our staff did do the best job that they could do and made the best deal, not only for these tenants, but for our goals as a council and our policies of moving forward with new housing. I think that this would derail it completely, and we might as well just vote no to the whole application if we're going to support this amendment. So I won't be supporting it. And I also have to say, when we go back to the next amendment, because this is an amendment to the amendment, again, I just urge my colleagues, vote no to the whole application, because this project isn't going to be viable. Before, when I had said I'd support it, it was because I heard the words that it would be expedited, but I appreciated that, you know, general manager of planning and sustainability and development clarifying for me that it would expedite things versus a referral. But this might not work in itself. Understanding that text amendment might as well be a whole new rezoning application as well. I urge all of my colleagues, if you're going to vote for this amendment, the amendment, or the amendment at all, just vote no to the whole project, because it's more clear, at least to the applicant, that they have to come back with something completely new, which is what they're going to have to do anyways. So I won't be supporting this. I won't be supporting the amendment beforehand. I appreciate the sentiment, Councillor Swanson and Councillor Boyle, in bringing this forward, but I just know that this will not work. And I believe in my vote that it's disingenuous to vote yes to this and say we're moving something forward when this will kill it and it will be dead on the floor. Thank you.
Councillor Fry?
Yeah, I won't take as long. I guess my metaphor would be moving the goalposts. This, I definitely appreciate this is the direction we would like to see things go, but I also recognize that this is a project that's been in the works for almost a decade, including the more recent tenancies, the pro formas that this developer has come up with, recognizing that there are very changing and fluid dynamics as far as inflation and cost of construction and materials. So I'm very supportive of this moving forward, this kind of direction, and we've talked a lot about it, but I don't think we're layering on too many last minute changes. I'm struggling with the amendment as proposed, let alone this amendment to the amendment, but I think we have to be realistic about what we can expect the private market developers to deliver. Again, this comes back to the fact of the matter is that we don't have senior governments, inserting themselves in this capacity to build this housing that we need. And we're trying to eke out as much as we can out of private developers, lest they walk away and just not do it. And I am struck by the notion that the outright zoning for this could allow something very different that wouldn't deliver the park or the rental housing that is being proposed here. And I think that would be a loss as well. So I won't be able to support this amendment to the amendment.
Thanks, Councillor Carr.
Thank you. I will just, I won't repeat what Councillor Fry said, but it's also my thinking. It is a good idea for us to look to in the future, but to make this last minute change on a project which risks the project, I just think it's irresponsible. So I won't be supporting.
Thank you. That's it. So we'll call a vote on this amendment to the amendment. That is Councillor Swanson's addition to Councillor Boyle's amendment, proposed amendment.
Mayor, I'll take a vote assist in opposition.
Thanks very much, Councillor Dominato. Clerks, if you could. Yes. Okay. That has unanimously failed. Okay. So going to amendment back to the original amendment proposed by Councillor Boyle. I'm just going to ask folks to mute.
For point of privilege, sorry, I didn't vote right on that. I won't ask for a rescind, but just know that I screwed up my vote on that. Sorry.
Clerks, if Councillor Swanson wants to be, do you require to be marked as voting in the affirmative, Councillor Swanson?
Yeah, that'd be nice. We could do that.
Clerks, I think we do actually have to go back and revote then in that case, don't we? To rescind the vote. I can't remember if it's rescind or reconsider.
Sorry, everybody.
Yes, it needs to be a revote. So just one moment, please.
Thanks. I think it's a unanimous. We need a motion and then a seconder and then a unanimous.
Okay, I move to rescind.
Do it the seconder.
Second.
Thank you. Clerks, I'm a little ahead of you here. I'll try an oral vote on that one first and just see where we are. All in favor of reconsideration?
Yes, correct. It's a reconsideration.
All in favor of the reconsideration, say yay.
Yay.
Any opposed? Okay, so we can do that vote again. This is on Councillor Swanson's amendment to Councillor Boyle's proposed amendment.
I'll take a vote assist in opposition.
Thank you.
Sorry, Mayor, are we on Boyle's amendment? I thought we were still on the amendment.
No, we had to reconsider Councillor Swanson's because Councillor voted in the wrong way. So this is a redo on the last vote.
On the amendment to the amendment from Councillor Swanson.
Right, yeah.
Okay, because I'm seeing the Boyle thing on screen.
You voted in opposition last time.
Yeah. All right. Just
okay. that still fails with Councillor Dominato, Boyle, Weeb, Fry, Dejanova, Carr, and Stewart in opposition. Thanks so much. Now we're back to the amendment. Councillor Swanson, anything else? This is on Councillor Boyle's amendment.
I think this is a good, not perfect, but it's establishing the right of bridge funding, which I think is something that we need to do more. We need to make that bridge funding a condition of the TRP, actually. So I think it's good that we're doing that here.
Okay, thank you. Councillor Carr, you have about 50 seconds.
Yes, I disagree with Councillor Swanson. This is not the right place to make to set a new direction, a new path like bridge funding. I totally agree with bridge funding. I totally agree with the intent of this amendment. It is in line, as I said, with the Broadway plan and now with the Vancouver plan. It is the wrong place to do it at the end of a public hearing where you have not alerted the developer and in all cases future developers to work with staff to do this and work it into their pro forma and the project financing. So I really want to see it happen, not in this way at this time.
Thank you. Councillor Fry, you have about 2 minutes.
Yeah, thanks, Mayor. I'm not going to be able to support this amendment much as I would like to. I do recognize the need for this, but I'm also hearing pretty clearly, from the developers that they're already feeling squeezed to shift this. And I think that this amendment effectively kills the project, knowing, or at least sends it back to significant rework, and hearing that we can't just do that through the process. This is currently policy compliant approach to everything that we've already done, and certainly we are looking to change it, but this application has been in the works for some time, and we've signaled some shifts on the tenant relocation and protection policy to enhance it, but we didn't do that before this came to us. So I'm worried that this will effectively kill this project, given that what the outright zoning allows for is a lot less delivery of the kind of public benefits that we're looking for, a lot less delivery of the kind of rental housing we're looking for. And I don't know how this works, and without the opportunity to really get that fulsome consideration from the developer, recognizing that this is a private developer that is putting forward a policy compliant project and trying to meet our existing policies, I'm not sure that I'm prepared to lose the benefits that will accrue for the city of Vancouver with moving forward on the proposed rental project that we're contemplating today. So I can't support this as it is.
Thank you. Councillor Swanson, you have just under 2 minutes.
And I think we need to remember that the developer said he was flexible. By cutting out a third of the tenants, we've reduced the costs of doing this by a third. We have the public art funding that we can dig into. We have, if the rental building gets built sooner, that will reduce the bridging cost. Why on earth would we not ask our staff to work with the developer to do this? I can't comprehend it. When we have all those tenants who came and spoke to us that are at their wits' end with stress. That's it for me.
Councillor Fry, you have.
Okay, so I need to then ask a point of information, point blank, to our staff. Does this force this project to go back to the drawing board and come back for a public hearing? Does this amendment effectively do that?
Point of information to staff?
It does not. It does not force it to come back. However, it does require the applicant to think through the project, the financial viability of the project.
Councillor Fry, that's it for you.
That's out for time.
Okay, don't see anybody else in the queue, so I'm going to call the vote on this one.
Mayor, I'll take a vote assist in opposition, please.
Okay, thanks so much. Okay, that fails with Councillor Dominato, Weeb, Dejanova, Carr, and myself in opposition. with Councillor Fry abstaining. Okay. Thanks so much. We are on to the main queue. Councillor Boyle.
Thanks, Mayor. I will just again say I have really wrestled with this project. I like the densities proposed, the mix of building types. I'm very happy to see 6 stories there and mixed rental and moderate income rental and townhomes. I, of course, appreciate the childcare and know how badly that's needed, and appreciate the green space as well. And I just continue to wrestle with this tenant protection piece. As I've said many times, my very strong preference always is that we be building new rental housing where there isn't existing secure rental housing, so that there is, you know, less to no displacement, and we're adding more rental housing. We've seen a few projects like that. I hope we see many more in every neighborhood of the city. Again, where we're building rental where there isn't currently rental, but in these rare, thankfully, during this term, proposals where new rental housing is being built where there's existing rental housing, I feel really pulled in terms of recognizing the benefits that this project brings, but having deep concern about what it means for the tenants in this building, who have many of whom have been living there quite a long time and who we know will have trouble finding affordable housing elsewhere. So we'll maybe just leave it there, that this has been a very complicated one for me, but it's certainly not because of the built form. And I hope to see more projects like this in other places where it maybe is replacing a number of a whole block of single family homes. I'll leave it there. Thanks.
Councillor Carr, up to 5.
Yeah. So let me start by saying, you know, the discussions we've been having through the amendments, you know, it was difficult, and I was very torn, and I was torn because, you know, we are already as a city and as a council and staff on the path to increase tenant protections. This is in the kind of middle of that process before we've actually enacted the changes. And I just want to be clear that the changes that we've embedded in the Broadway plan and the Vancouver plan to very much increase tenant protections to become maybe the best in all of North America, that's the right path, and we all know it, and that's what makes this decision so hard around those amendments and wanting to see better protections now. But the time to do those changes is not at the last minute in a public hearing. It is just not the right process. It's not fair to all those who have been in, those who put the application forward, and it's just not right. And we don't even know what the solution, if we pass those, would have been. We heard clearly from the applicant, it would make the project a no-go. I don't want to risk this project. I think this is a good project. I wish there were tenant protections in place already. They aren't, but it's still a good project. I like the housing. I like the housing mix. The range of sizes of units, that's all good. There are going to be protections for the eligible tenants, not as far as we want to see them go, and they will go in the future. But that's a good piece. I really like the park, the fact that it's a public park, that there's childcare, there is landscaping and greening of the area. There's food gardens, food assets. These are critical things, and more greening of roofs. I saw that in one of the conditions of approval, and more trees and larger trees that would be planted to replace the trees that might have to come down through the development. These are really important for quality of life, and for combating climate change, and for ensuring that we have got a lot of housing. through this development that is desperately needed in the city at some really affordable rates. So for those reasons, I am going to support.
Thanks very much, Councillor Carr. Councillor Swanson, up to 5 minutes.
Yeah, I think it's really important to get this project right. I think it's important because there's hundreds of other Balfour type units, precious, larger units at precious reasonable rents. It's important because we're planning to densify the whole city and we need to preserve the affordability that we have and protect the tenants that are in those affordable units. So in this case, we have 34 reasonably affordable units, and most of them are in three bedroom, which are in really short supply. When I saw this project, I thought, great. If it replaced the affordability, it destroys and protects the current tenants. But if we don't get tenant protection, the folks who benefit from the amenities, the childcare, the public art, they're going to be the richer folks. Everyone is concerned about the poor developer. I'm concerned about the current tenants. Whose quality of life are we talking about? This is a problem. Are we going to let landlords empty out buildings or allow tenants to live there only if they sign away all their rights and then require only that they replace what is occupied? This will incent landlords to leave units vacant and get these horrible no disclosure agreements. And without bridge funding, the current tenants will be in serious financial trouble. We'll probably have completely different lives in different places before the new development is done, and won't return to the new place, so the landlord won't have to rent at the old rate. It's not a good strategy if we want to protect low-income renters. We can't operate like this. We need to protect the tenants and the affordability that we have. Our TRPP is virtually useless and needs a total revamp, especially in light of the Broadway and Vancouver plans. This rezoning will be a precedent. If we allow developers to demolish and not even replace the affordability that they destroy, we're not meeting our equity goals. We're not meeting our affordability goals. We're pushing low-income folks out of the city. That's it for me.
Councillor Weed.
Yeah, I appreciate the dialogue today, and I agree that our tenant protections are not there yet. And as much as we put them in Broadway Plan and others, they're not enacted. And so we're going to see significant pressure on more and more rental stock in a lot of portions of the city, especially in the Broadway area, because these aren't actually policy yet. And so we will continue to see projects like this come forward that meet policy but don't protect renters in the way that we need. I also think that this property has been able to deliver more amenities than we traditionally see, and that was talked about today, where we have been able to get green space, food assets, childcare, and others in low-level density and human scale design. And so I think that this is kind of one of our first projects that's really starting to bring in a lot of the elements that we want to see in future designs, mixed tenure, rental, strata, all in one project, in a different neighborhood that hasn't seen a lot of density with great amenities nearby. So I think this is the type of living arrangement a lot of people would like to see in Vancouver. It's just we need to find ways to make sure that we aren't wrecking our affordable tenants, our rental stock in Vancouver, and that we get our tenant protections right, and make it so that it's clear and transparent, so that it's done in an early process of a development process, so that it's fair and can be feasible and built. So I will be supporting the project today.
Councillor Fry.
Yeah, I guess I'd like to start by just correcting a mischaracterization that everybody was worried about the poor developers. I don't think that's really been the case. I think most of us recognize that this is a really difficult situation where we're talking about displacement of a significant community on this block, but also recognizing that we are hitting on developers to deliver us the kind of housing that we need and come forward with development proposals that are compliant with our policies, which this particular project has been quite compliant with the existing policies. And certainly this council has shifted direction of late, and we're really looking towards more robust tenant protection policies that will hopefully form future considerations of this nature. But in the meantime, and in the absence of senior government stepping up to the plate to build the kind of housing that we need and the kind of volume that we need, we are stuck trying to eke out the kind of housing we can from developers. Now, this particular project does deliver, I think, quite a bit on the public benefit side that Councillor Weed just articulated, and I think also in addition is delivering some of the rental housing that we need. Yes, it's not affordable in the same kind of level that we would like to see, but it is the direction that we have set and established through our policy. And this is a project that I think they've held this for close to 10 years. Certainly it's been in the works for over 5 years. And recognizing that we can't just change the parameters and the goalposts and expect it to still be viable, I think is a pragmatic limitation of the role that we find ourselves in. And again, in a position where we're not able to actually fund this and build it ourselves, and we're trying to eke out the crumbs from developers. So all that said, I am sad for the tenants who are going to be losing the sort of sense of community that they have there, and I hope that many of them are able to return and find that again. Obviously, recognizing that we have to facilitate more and more of the kind of housing we need to house folks who live and work in our city. But all that said, I think the outright zoning for this parcel would deliver something entirely different, and I think that what we're getting instead. So by right, the developers could knock down this whole thing and build, townhomes for sale and make their money and get out. I think what we're doing here is at least, I think, on its own merits, a very good project with obviously some really fantastic public amenities. So on that level, I do want to thank staff and the developer for putting together this project. And I do want to acknowledge and thank all the folks who came and spoke to it. And I am sorry that this is not going to preserve the current scenario that everybody knows from the Balfour block, but recognizing that that we don't really have a choice because the outright use for this could be something entirely different. And we're doing the best we can with the limited tools that we have here at the city in our capacity as land use decisions. That's it.
Councillor Swanson, you have just under 3 minutes.
Just wanted to emphasize that the developer said he was flexible. He was flexible. The finances are really close. We could have done this right. It isn't a choice between doing it or not doing it. That's all.
Councillor Dejanova?
Thanks, Mayor. I just wanted to note, first of all, that in my closing comments, I really appreciate each and every person who came out to speak to us, on this application, whether they were in support of this and really excited for opportunities there might be for their family because they live in this neighborhood or want to live in this neighborhood, and also to the tenants. It personally pulled at my heartstrings hearing the stories and understanding, especially from some of the tenants who talked about wanting to keep their kids in the same school or the same catchment area, the uncertainty that was causing them distress, and that wasn't lost on me. And I think that when we look at our tenant, protections and our tenant relocation policies, and processes, that's certainly something that we need to consider. But I'm also reminded by the fact that we are in public hearing, which is a quasi-judicial body, that we are to consider, council, whether or not this project complies with policy. And it's clear from the staff report and the questions that we've asked that yes, in fact, it not only complies with policy, but the applicant or the developer could be doing less. They could choose to build townhomes. They could choose to do something else. All of these questions have been asked and answered. So while we're trying, to stretch this out, I've heard some councillors say, well, there's flexibility. I haven't heard, Councillor Swanson, to your comment that there's flexibility. Show me where the flexibility is in the pro forma, because these pie in the sky ideas that we can't ask the applicant if they can execute could just mean starting at square one. And when we look at developments like Little Mountain, how unaffordable has that made our city? When we look, council, back at this past term, developments such as, you know, the one on Granville Street. How much more unaffordable was that when the applicant had to bring that back to us years later? And they could have built a 20,000 square foot town or 20,000 square foot home instead of building townhomes. So when we look at this in the bigger picture about what this is providing, I have to separate out the fact that, yes, this shows me that we have more work to do, council, or the next council has work to do on tenant relocation policies, and to make sure that we do what we can to work with the Vancouver School Board, to work with the provincial government, to make sure that there are enough school spots, to make sure that we're considering, you know, how this is going to break up families or change lives, as the tenant shared with us. But in this specific rezoning, we have to base this on policy. And does it comply with policy? Is the applicant meeting the TRPP? And they are. So for that reason, I am going to support this. Do I hope and do I know that this applicant who has come before us before has every intent in doing right by the tenants? We've heard that. We've heard that they will try and do what they can and that there is some flexibility. And I have to trust that they understand that, because I don't have their pro forma in front of me. And none of the other ideas that I've heard here through amendments offer me that certainty that we won't be back here in a year with a more expensive project that won't meet our housing goals, you know, and create those amenities, that we might lose amenities because of the extra cost and the lag in time here. We're not known as a municipality that gets things done fast. And let's not make those processes slower. So while I do, you know, I certainly do feel for these tenants, and I do hope that you do find housing close by and that you will return. And I understand that there's a reason for tenure and the way that this is calculated out. I agree that there is work to be done on our tenant relocation, you know, policies and processes. But here, council is not a place we are allowed to do that work. So for that reason, I will be supporting this project. I think that we also have to balance this with creating new housing opportunities for the tenants who are there currently, to make sure that they're living in appropriate housing, and for other people in our city who need housing, and understanding that we don't have the right supply yet. So I'll leave my comments there, but I will be supporting this.
Thanks. That's it for comments here. So we're going to move to a vote on the unamended staff report.
Mayor, I'll take a vote assist in favor, please.
Thank you, Councillor Dominato. Clerks will change that. Okay, I'm going to call the vote now. This passes with Councillor Boyle and Councillor Swanson in opposition. Thank you so much, Council, for that work this morning. Thank you to the applicant and to the staff for all their work, and for those who called in to participate through the process. I think, clerks, we're just, sorry, I've just closed my script here, but we are, we just need a motion to adjourn now at this point, correct?
So move, Councillor DiGenova.
Just going to make sure I haven't missed anything from the clerks.
Yes, you need a motion to adjourn and a seconder.
Great. Yeah, great. Seconder on this one, motion to adjourn?
Second.
Thank you, Councillor Weave. All in favor, yay?
Yay.
Any opposed? Great. Thank you so much, Council, for your work this morning. Just a reminder that we're reconvening in a public hearing at 3 p.m. to finish, hopefully, the Arbutus. So we'll see you at 3 p.m. Thanks so much.